Hello everyone, thanks for coming today. My name is Eric Fausner. I'm the Executive Online Editor of the Golden Gate University School of Law's Law Review. And today we're here to talk about our first annual Digital Symposium edition on ethical prosecutions. I'd like to thank the Federal Bar Association for providing food, the Society of Litigators for helping promote this event, and Professors Wes Porter and Caren Cambre for coming and helping us deliver a great message on a great class and a great thing we're doing here at GGU. So to give a little background, the Digital Symposium edition of the Golden Gate University Law Review is an opportunity for students who are not on Law Review to be published, which is something that I don't think any other law school in the country does. And the way that you can get into this opportunity is by taking Professor Cambre's class this spring. It's called Ethical Prosecutions, and I will let her talk about the class and how it works. But I had the pleasure of reading all of the papers from last year, and there's some excellent ideas on how we can make prosecutions more efficient, effective, and, of course, ethical. So I'm going to turn over speaking to Professor Cambre to talk a little bit about her class and what goes on in it.
Well, for those of you who don't know me, I am Professor Cambre. Big ticket item. Wow, this what an introduction. I'm going to start by saying that despite what Eric says, you will not find out what goes on in my classes. There are rules against that. You don't find out what happens in there unless you're in there. But Ethical Prosecutions is a course that I believe this is going to be our third or fourth semester, maybe fourth, this spring. That we are offering this class, and the reason that this has come about is I am a 30-year plus career prosecutor. I have that kind of blood or DNA or something that makes me a prosecutor. So when I started teaching here at Golden Gate, I realized that there were not very many of us. There was me, and then there was Professor Porter. We were kind of outnumbered by defense lawyers. And there was a lot going on about wrongful prosecutions. We actually have a course called that. And the Innocence Project. There's a lot to be said for people being wrongly convicted. Well, I understand that people are wrongly convicted. So my thought was, well, instead of examining all of these wrong things that happen, let's teach our students who are going to be prosecutors how to make sure they don't happen. So I proposed a course, and with a lot of input from Professor Porter, we put something together that examined when prosecutions went wrong and why and how, and what do we need to teach prosecutors to fix that. We called it Ethical Prosecutions because the ethics of a prosecutor is really the baseline of when things go wrong. If you have an unethical prosecutor, you're going to have a prosecution that goes wrong. I had the pleasure of teaching professional responsibility about the time that we were formulating the idea for this class, and I realized that in professional responsibility, of course that's required here, you all get maybe one day about the special role of a prosecutor. Even the ABA in the model rules indicates that the prosecutor has a special role, and we don't really spend much time teaching you what that is. So that was sort of the core of why we came up with ethical prosecutions. The real reason in my heart was, those of you who know me know that I'm from New Orleans. And back a few years ago, there was a very important Supreme Court case that came out. A man was wrongfully convicted, Mr. Thompson, the Thompson case, out of New Orleans, Harry Connick's office. He said he was wrongfully convicted, and there was all kinds of fun facts that if you take the course, you'll learn about how they managed to really mess this up, the prosecutors. But what happened was they gave him, the courts gave him, after he got out, $14 million in a judgment. Well, this made Mr. Thompson very happy, obviously. He's been in jail a long time, he gets out, he's got $14 million. Whoa! Well, The DA's office did not like that ruling at all because they gave him $14 million because they said the district attorney's office made mistakes. They were unethical prosecutors. They violated some of the rules. The DA's office said, no, we didn't. We don't want to give him all that money. We don't want the state to give him all that money, so they appealed it. They appealed it all the way through all of the Louisiana courts, and it was upheld. So Mr. Thompson was, I think he was probably starting to spend his money by now, his whole $14 million. But what happened next was New Orleans was in trouble. I was there about the time this was happening. They were trying to figure out where's the city of New Orleans going to get $14 million to pay Mr. Thompson. We were still reeling from Katrina. We were in bad shape. We didn't even have a DA's office. The whole DA's office had gone underwater. Where are we going to get $14 million? The city was actually talking about, what are we going to do? Who's going to prosecute our cases? I mean, these people can't do it. They made all these mistakes. Nobody taught them how to do it right. So it went to the United States Supreme Court. You know, the big one, the one in D.C., the big court. Louisiana sometimes thinks, you know, we're part of the South. We don't have to follow their jurisdiction. But when the Supreme Court speaks, people kind of have to listen. Well, the Supreme Court looked at Thompson. Guess what happened? They overruled it. They said, Mr. Thompson, you're not getting anything. Well, what kind of a furor do you think that set up with the Project Innocence people? And all of those wrongful conviction people that are unhappy that, wow, how did this happen? Well, about that time, there was another professor here teaching a course about things that happen in criminal court, and said, would you come talk to my class about Thompson? And I said, sure. So I studied it in great detail, and what Thompson basically said was, we're not going to hold the city of New Orleans, or more specifically the district attorney's office in New Orleans, responsible for these prosecutors being so unethical and doing these bad things. They did not say that they didn't do bad things. They just said, we're not going to hold the DA's office responsible for this. And in a paragraph that I was very happy to see, they said, the responsibility for teaching prosecutors the rules about Brady and other ethical issues falls squarely on the shoulders of the law schools. Well, you better believe that paragraph was in my memo that I drafted and sent to the dean when I said we need a class called Ethical Prosecutions. So that's what Ethical Prosecutions is about. It is a response to the idea that, number one, you don't get enough of it in PR, and number two, there's actually case law out there that says this is a project we need to take on. So I wish I could tell you that I was forethinking enough that we should write a paper so that we could come up with this great symposium idea. Well, the truth of the matter about that is, I don't really like to grade exams, and there wasn't really a good way to grade this course, but it lends itself beautifully to writing a paper. Because you, in ethical prosecutions, if you take the course, will be told to take a position on something. I know that's hard. We don't want you to debate anything. I just want you to take a position. Either you think that prosecutors should do this or they shouldn't do that, or the rules should be different. So I propose that the students write a position paper at the end of the course about how do you feel about these different topics. And it's really important for you to look at the opportunity to have something published, and for the school to have their students publishing things. So it was kind of the best of all worlds for everyone. And at that point, I was getting all these great papers on terrific topics, and I said, we need to do more with this. And that's where the law review came in, and they decided that they were going to set up this symposium idea. I take none of the credit for that. The credit goes to Professor Porter and to the law review students here who have created something that I think is the first for our school, right?
Yes.
An online symposium. It is, the students are doing videos about their papers as well as being able to present them and have them published in a fashion that I think two good things are happening, well, three good. The schools, it's good for the school, it's good for you as the student, and you know what? It's good for everybody that we're talking about these topics. We don't want people going to jail who are wrongfully convicted. We want prosecutors to do a good job. And this, I think, fosters that in a way that goes far beyond just my my 2-credit course. It goes beyond that. People get to read about it. People get to write about things that mean something to them. So at this point, I think I'm going to turn the program back over to Eric. I believe he has some time allotted at the end that we can answer questions, but I hope I've given you sort of an overview of ethical prosecutions and how much you would enjoy that class, and why doing that and writing a paper is a win-win for everybody.
I'd like to reiterate Professor Cambre's point that it's great to take an opportunity to take a position on something. You don't get to do that often in law school, and having an opportunity to talk about something as important as people going to jail for the wrong reasons, it's a great thing to write about. And if you're interested in writing about it, we will have time at the end to answer some questions. But next, I'm going to turn it over to...
Wait a minute, Eric. Can I interrupt you for 1 second?
Yes.
It's just the ethical prosecutor in me. There's something really bad about people going to jail for the wrong reasons, but there's something equally as bad about people getting out of jail for the wrong reasons. It's a double-sided coin.
It's true, and the solutions that students propose in these papers take really interesting approaches, kind of out-of-the-box approaches at addressing these issues to make prosecutors' offices run more efficiently, run more fairly, with more transparency, and getting better results. And that's for prosecutors putting the right people in jail and then keeping the wrong people out of jail. And that brings me to a professor that is contributing to the Digital Symposium with an excellent paper that will be published this coming year, Professor Wes Porter.
Thank you, everyone. And I thank both Professor Caren Cambre and Eric Fausner as well. It's interesting. I love coming up with ideas. I love thinking outside of the box, and I like thinking about what next we can do around here to bring attention to the wonderful stuff that goes on in our school, including down to classes and including the work of our journals. So it's even better to have an idea that we should have a course like Ethical Prosecutions and have someone as fabulous as Professor Cambre actually carry that vision forward and take it to the next level in what she's able to do with the students. It's great in the second instance to say we should really do some kind of online symposium. We should really have something where we have a digital presence for our journals, because we've seen things like this happen other places. And to have a forward-thinking editorial staff of this year's law review to actually carry forward that vision. So I couldn't be happier to show up here today as sort of a contributing author and just to give you a talk knowing that some of these ideas that we talked about, some of these ideas that we had way back in the day are actually realized. So it's very exciting. I also think it's a great thing. I was part of law review and I wrote the formal piece, but I got to tell you, in joining academia after being a practicing attorney, you start to realize the value of taking positions. You start to realize the value of having sort of opinion pieces in other forms come out and become more readily available in the public. I love writing blog posts. I love writing op-eds. I love writing things that you hear something going on in the world and it turns your ear sideways and you're like, nuh-uh, that's not the way it works. Let me say what I think about it. And I think this symposium and these types of papers allow not only a forum for that to happen, but also allow students to have their voice heard. You don't need to have 30 years of experience or be a career prosecutor like Professor Cambre and me to have sort of thoughts as to the way the system could be bettered. And I think that's the best part about some of these papers. And I'd love for some of these ideas to then be realized visions coming forward, because I've read some of these papers too, and they're wonderful. With that said, one of the things that I thought I'd do, I took the syllabus to the course that Professor Cambre hands to her students, and I took the sort of mandate that she puts out there for her papers after they learn the backdrop of what happens in the context of criminal prosecutions, what happens that sometimes results in these wrongful convictions, and says how could we make it better, what could we require as far as different process, or what can we do to improve our American criminal justice system, quite frankly. And I put it to me. I said, what would I do? And I think the interesting part about that in leaving a career in prosecution that I had and joining academia is I've done that several times. I like to look at where I came from and said, you know what? I may have operated under that system. Those may have been the rules that I accepted and the playing field I accepted, but it didn't make it right. And there are things that could be better. So what I'm going to talk to you about today in preview of the article that I wrote for the online symposium has to do with dismissed indictments. I think there's been a great light shown on the criminal justice process in the recent years through these kind of waves of exonerations. Most of it has happened through post-conviction DNA work. We've seen that we've taken evidence and had it tested after the fact, and we've actually exonerated hundreds of folks. Project Innocence has done a great job in that respect of carrying forward the advocacy and making sure that we get evidence that we have in some of these criminal cases, getting them back to the lab, getting them tested, and actually exonerating people, showing people to be factually innocent of the charges that were brought against them. Can you imagine anything more wonderful that you could do with your legal career and with your legal training than to help someone's life in that way? It's amazing. From my perspective, the even more important part of it than the result for that individual that is exonerated is what lessons can we learn. DNA, post-DNA exonerations are wonderful in the sense that not only have they created some freedom and liberty opportunities for those individuals, but we now look back and say, what went wrong in their case? How is it in our American judicial system, in our criminal justice system, how is it they were convicted unanimously, beyond a reasonable doubt, if they were factually innocent? What went wrong? And I think through that work, we've seen problems with the way prosecutors handle witnesses. We've seen false confessions, false identifications. We've started to actually add terminology to the problems that we can have. And it's shown this great light on a lot of these problems. Well, my paper has to do with dismissed indictments because I think it's another area, a broad topic, a broad avenue by which we can show some light on where things go wrong. So let's say we don't go all the way through the process. Let's say we don't have a conviction and someone's sitting in jail for years or even decades before Project Innocence or like-minded organizations get their evidence and have it tested. Let's say instead we actually look at the circumstances surrounding when an indictment, or more so a conviction, is dismissed by the prosecution. Because the point of my paper is, and part of it is an existential example, part of it has to do with looking at some famous cases. Whenever we have a dismissed indictment, my theory is there's a larger story to tell that the public never knows. When you have a dismissed indictment or a dismissed conviction, essentially what's happened is the government walks in and says, yeah, we might have troubled citizens in our community to return an indictment. We might have brought a matter to a grand jury so that it's been ratified by the public, by people, ordinary citizens that say, yes, there is probable cause that a crime was committed, and yes, there's probable cause that this person committed it. But we're backtracking now. We're saying that's not the case anymore. We're dismissing this indictment. Or worse, imagine you take a case to a pettit jury and you put on a full trial with witnesses, exhibits, and everything else, and you have a jury come back and say this person is guilty beyond a reasonable doubt, the highest standard that we have in our system, unanimously among the verdict. And after that type of pronouncement from our community, you say, we're dismissing this conviction. Now, oftentimes, if the government is the one to dismiss, of course, it's an unopposed filing. The defendant just wants out. The defendant just wants their matter resolved. But can you imagine the larger story that lies behind the curtain? There is always a larger story when indictments are dismissed and when convictions go away after the fact on account of government filings. That's the type of introspection that we should be doing next in our system. We shouldn't wait until it goes all the way through the process. We shouldn't wait for scientific findings of factual innocence. Instead, we should actually be looking for when is the government, upon its own action, taking steps to dismiss indictments and dismiss convictions. So the existential example that I'll touch upon in my article has to do with, I called an officer in a case, and I indicted a case based on an officer's reports. I talked to him on the phone. He was geographically far away from me, but I talked to him on the phone, talked about what happened in the case. It was what you might describe, law students reviewing files, what you might describe as a routine traffic stop, where we found guns and drugs, and the defendant was the one driving. It wasn't terribly complex, and didn't spend a terrible amount of time trying to figure out what I was going to do before the indictment. I was going to go forward. And then I had a motion to suppress filed by the defense. Again, didn't think much of it. It lacked a lot of substance. It just looked like sort of a routine challenge to a criminal case where items, prohibited items were found pursuant to a search. And then the officer came over to testify in the suppression hearing. He finally made his way into my office, finally had a chance to meet him face to face. And I was actually going through, for you litigation students out there who have me for litigation, I was going through sort of a mock cross-examination. Sort of here's what you're going to be asked about today in your suppression hearing. And very quickly that mock cross-examination turned into a genuine fear about the legitimacy of this officer's testimony. I was asking questions and the answers were all over the place. There were inconsistencies, there were gaps, it just didn't seem to make a lot of sense. And then all of a sudden I started to have that pit feeling in my stomach, that empty feeling where, oh my goodness, I'm not sure if what this person actually put in this report, what this officer said happened, actually happened. And this wasn't an ordinary drug and gun type of case. As is popularized in the media nowadays, this was the type of case that had mandatory minimums. This defendant, upon being convicted, probably beyond going past this suppression hearing, was going to face 15 to 25 years, 15 years minimum. So I quickly turned my mock cross-examination into a legitimate questioning of what happened. And at that point, the officer said to me, well, it's not exactly the way it happened. The version differed slightly from the simplified version that I put in my report. From that point, my day changed. That suppression hearing got canceled. I was in meetings with supervisors all day about how I had to dismiss this indictment and how I could not go forward on the case and how I had to save this officer's career by not putting him on the stand to get exposed in this way as he was in my office. I spent a lot of my day counseling the officer and calling officers in the supervisory chain back there to make sure this mistake didn't happen again. It was one of the greatest lessons that I learned in my young prosecutorial career. But the interesting part about it, as I write it here today for the purpose of this article, it was a lesson that was for me, for the narrow people that knew about it, and not one that was going to be transferred to future prosecutors in future circumstances. I told that officer that every time you write a report in any criminal case, you treat it like an affidavit that you're signing it and you're adhering to the truth of everything that's in it. That lesson, too, doesn't make its way to all new law enforcement. It had to happen to that officer, right? And for this prosecutor, you can bet that my approach changed with the next officer that was in my office, the next officer that I had to interview over the phone, the next time I was dealing with a quote-unquote routine traffic stop or a routine suppression hearing. And that carries forward. So that was my story about how there's a larger story to tell, because until I read it in this article, until I share it with you today, not a lot of people know about what I just talked about. And you know what? Every prosecutor's got a handful of stories just like this. And it's not that they're part of any training manual or book or series to make sure that they know. It's classes like Professor Cambre's. It's online symposiums that shine light on this issue that are going to bring it forward. And with that, I transition in the article to a famous case. It's actually a famous case where Professor Cambre was intimately involved, also happening in New Orleans. If you want good ethical prosecutions cases, you can stay in the confines of the state of New Orleans and do just fine. But this is the case, and it was popularized in a 48-hour special that kind of goes through of Damon Thibodeau. It was a defendant that had no criminal history, never been involved with the law. Young guy, actually just moved to, relocated to Louisiana, and there was a young girl in the family that he was staying with that he was quasi-related to. And the little girl went out for a trip to the local supermarket and never came back. The body was found underneath a bridge nearby. And quickly, very quickly, as the family, including David Thibodeau, went out on a search party, very quickly the cops narrowed their focus and narrowed down on him as a suspect in the killing. For various reasons, it not only became a murder case, but it also became a capital case in Louisiana. And it went forward in a bunch of different directions. Professor Cambre would tell you that the case and the investigation sort of turned on the fact that Thibodeau was brought in for a long period of questioning from the investigators. And after that, confessed to the crime and actually confessed to rape going along with the crime. Confessed in detail to certain aspects of this crime. So you can imagine, it was a case of corroboration, a case of confession, a case of the body being found, a case of proximity and timeline, and all the complicated things and normal things that happen in criminal prosecutions. Well, it resulted in a conviction, and it resulted in the jury's pronouncement of a capital sentence for Damon. That began the long process of appeals, and collateral challenges, and attacks, and different approaches. And in all of those, at the trial level and all the levels of appeal, he talked about his false confession, raised his false confession. His false confession, or the issues surrounding his confession, were actually raised at the jury level, to the trial, and of course rejected with their verdict. Also, successfully defended on appeal. The state of Louisiana won every single appeal. Conviction was upheld, and the capital punishment was upheld. Project Innocence folks and others, other friends on the defense team, still worked on the case for years and years after, just like they do in most capital cases, particularly ones with someone with no criminal history and a claim of false confession like this case. The other issue that came up surrounding this famous case had to do with no DNA. All sorts of articles of clothing and other physical evidence was recovered in the case. No DNA ever connected Thibodeau. It was just his confession and some of the other corroborative testimony and witness testimony and the circumstances that were put on in trial. But interestingly enough, in a kind of an unprecedented move as documented in the 48-hour special, the defense team decided while these appeals were going up and down and challenged in every way, shape, and form, centrally on the issues of false confession and no DNA evidence, no physical evidence, the defense team decided to make a presentation, a post-conviction presentation to the government, where they said something went wrong and that this was still wrong and that Thibodeau was innocent. Thibodeau was innocent. So the DA's office, and another unprecedented step, especially for a capital case, began its own reinvestigation, a 5-year reinvestigation that went from 2007 to 2011 into these events, and essentially, at one point, dismissed the case. Not only dismissed the ultimate punishment that was going to come for this defendant, but dismissed the indictment. Like he was never charged, and he walked out free. Now it was heralded as another exoneration, an exoneration of a death penalty, death row inmate, an exoneration of someone that had no criminal history, an exoneration, they say, was based on DNA. But I already told you that this trial, and the trial that Professor Cambre put on, didn't have DNA as part of the evidence at trial. And the false confession that was claimed at all levels of appeal and rejected also was litigated at trial and rejected by this jury. So there's something serious that goes on when the community, the jury, makes a pronouncement about what happened in a criminal case. And the prosecutors, on their own, make it go away. I'm here to suggest that something larger was going on in that case. There's a larger lesson to learn, just like my very simple example in the routine traffic stop, about what happened in that case, what was going on behind the curtain. And the key is, will we ever know? And I'll leave it to the article to tell you how this thing's turning out, because it's still unfolding right before our eyes. But you should know, just like, what was his name, Thompson? Just like Thompson, Louisiana, they have an act. They have legislation in the state that actually facilitates wrongfully accused folks, exonerees, to be able to file a claim to get paid out like Thompson was in his $14 million before the appeal was overturned. And it's usually a pretty routine thing. If you were factually innocent and you're an exoneree and your conviction was dismissed, you file your claim and you get, essentially pursuant to a formula, you get reparations. Well, in this case, having to do with Thibodeau, it's not going so smoothly. They're not readily paying out that claim. Matter of fact, there's a dispute as to his factual innocence even after the dismissal. Something more may be going on. And there's also things going on with a lawsuit that he has filed. You know, you see this every now and again, even with some of these reparations and some of these claims. You see that the exoneree sues the prosecutors or sues the police department or sues people involved with how he ended up on death row wrongfully. Well, in this case, it's not suing the prosecutor's office. It's only suing the sheriff's office that investigated the case. Something more may be going on. So we have stuff after the fact, this disputed claim, this lawsuit that leaves out the prosecutors and targets the sheriffs only, and essentially a prosecution decision to let someone go who was formerly on death row, to let someone go who was convicted at jury trial, pronouncement of the community, and let someone go who was not only convicted, but said to have, the capital punishment imposed against him, again anonymously, again by the jury. So my point of the whole article, and I hope that you read it, and I hope that you read the other papers that are in the online symposium, the point of the whole article is maybe the next big area, now that we've moved past post-conviction DNAs to show some light on the problems in our criminal justice system, maybe the next big area is looking at the prosecutors themselves. Maybe the next big area is looking at those instances when they back away from an indictment like I did, or when they back off of a conviction as the community has pronounced them by their jury verdict. Maybe we should start requiring more ex parte hearings with judges, referrals to bar associations, something, some type of process where we can aggregate what happened and learn from it. Something where we have to make sure that future prosecutors like you are actually able to benefit from some of these lessons and proceed more carefully in the prosecutions that you lead.